We'll hear argument next in Case 13-517, Warger versus Shauers. Mr. Shanmugam.
Thank you, Mr. Chief Justice, and may it please the Court. In McDonough versus Greenwood, this Court held that a party is entitled to a new trial where it can show that a juror was materially dishonest at voir dire, regardless of whether the juror's dishonesty actually infected the verdict. A McDonough claim is thus an inquiry into the composition of the jury. It is not an inquiry into the validity of the verdict. And for that reason, Federal Rule of Evidence 606B unambiguously permits the introduction of testimony about statements made during deliberations in support of a McDonough claim.
But wasn't that a case in which a third party came and gave the information?
That is correct. And so we are certainly not arguing that McDonough itself resolved the question of the scope of Rule 606B. But we do think that the nature of the McDonough inquiry is really critical here in determining whether Rule 606B applies. And in particular, we think that the critical fact is that McDonough in no way requires an inquiry into what actually took place in the jury room. It is, as we say in the briefs, a type of structural error, and by that I mean that it has no prejudice component. And in that regard, it is critically different from other types of claims, such as a claim of outright jury bias, where prejudice is required. And it's really for that reason that we think Rule 606B unambiguously permits evidence of this variety to be admitted.
I thought that the whole rationale behind this is we don't want to invade the jury province with information about what went on in the jury room. And that's a pretty old rule. And some people may think it makes no sense. You can have an eavesdropper, and that's okay, but you can't have a juror itself. So what's involved here is a juror reporting what she heard during the deliberations. And it seems to me that's exactly the kind of thing that is not permitted.
Justice Ginsburg, we're certainly talking about statements made during deliberations, and we are not disputing that this is the type of evidence that is subject to the rule. Our argument concerns the first requirement of Rule 606B, which goes to the type of inquiry during which evidence that is otherwise covered by the rule would be admissible. And I do think that Rule 606B embodies a balance. It isn't simply about the countervailing policy concerns, which Respondent and the government understandably emphasize, of finality and jury secrecy. There is, of course, a countervailing concern here about fairness. That is, after all, the principal concern on which the rule of McDonough itself was based.
But it's too easy to convert anything that occurs into the jury room as reflecting on the voir dire. So the judge instructs the jury, can you follow my instructions? Oh, yes, I can follow my instructions. In the jury room, that juror says, oh, come on, let's just average it all up and go home. Didn't follow instructions. I think on your theory, that could come in because it goes to dishonesty at the voir dire stage.
So two responses to that, Justice Ginsburg. First of all, as we point out in our reply brief, our rule has been the rule, both on the federal level and on the state level, in numerous jurisdictions. And we would respectfully submit that there is really no evidence of the floodgates problem that Respondent suggests will follow if this Court
adopts our interpretation. Well, perhaps if you prevail, why not?
Well, that goes to my second response, which is that I think that it is going to be very difficult in the hypothetical you posit for a party to make out a successful McDonough claim. And that is simply because the requirements of McDonough are, in fact, quite stringent. And in particular, the first requirement of McDonough is that the moving party must show that the response was intentionally dishonest. And by that, I think that the Court really meant intentionally dishonest at the time of voir dire. So to take the hypothetical that the government uses in its brief
I think you're missing the point of Justice Ginsburg's question. The question is not whether the McDonough claim ultimately would prevail. The question is whether the testimony from jurors about what went on in the jury room is going to be solicited in an effort to prove a McDonough claim.
Well,
and I guess your answer to what the implicit in what you're saying is that it would be permissible to receive that testimony in that situation.
Well, Justice Alito, I think there are two separate issues here. The first is the concern about undue solicitation. And as we have explained, there are a variety of rules that I think impose appropriate limits on a lawyer's ability to go out and get evidence of this variety. And, of course, lawyers always have an incentive to talk to jurors if they are able to do so. Our point is simply that to the extent that there is a concern raised about harassment of jurors, that is already dealt with, and appropriately so, by governing rules. Now, I think Justice Ginsburg's
I'm sorry,
question
I didn't follow that. You said lawyers always have an interest in talking to jurors. What's to prevent them from doing so if the payoff could be as significant as you're looking for?
Well, I think at a minimum, Mr. Chief Justice, lawyers certainly would have that incentive even if we were to lose this case, because in talking to jurors, that conversation could very well lead to evidence that unquestionably would be admissible.